Welcome to our continuing educational webinar series. I am Catherine Short, Partnership Marketing Manager for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility, and we help manage every aspect of a compliance program, and our training library provides hundreds of modules that are easy to assign and track. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Trey Scott, coordinating attorney at Kennedy Attorneys and Counselors at Law, back with us today. Trey received his Bachelor of Science and Master of Business degrees from Texas Tech and his JD from Texas Wesleyan School of Law, now Texas A&M School of Law. While in law school, Trey was a member of the arbitration competition team as well as a student bar association representative. He was also a law clerk to the 106th District Court of the state of Texas. Trey has significant experience in healthcare law. This experience includes medical malpractice litigation, administrative and regulatory appeals and disputes, professional board matters, and overpayment disputes. Trey is licensed to practice law before Texas state courts as well as the United States District Courts for Northern, Southern, Eastern, and Western districts of Texas. Trey is also licensed to practice before the United States Court of Appeals for the Fifth Circuit. Before we begin, I'd like to mention at First Healthcare Compliance, we strive to serve as a trusted resource for compliance professionals, and every month we celebrate their hard work and dedication with our Compliance Super Ninja recognition. Today, our team is turning the spotlight on Super Ninja Sharon Miller, administrator at Gulf Coast Dermapathology Laboratory. Sharon says patient care is paramount, and by creating a culture of caring, compassion, and respect, we have succeeded in all we do. We try to promote a family atmosphere, which in turn translates to ultimate patient care. Congratulations, Sharon. Our team is honored to have the privilege of working with you. A copy of the slides is available for download on the control panel. Feel free to submit questions into the question box of your control panel during the presentation. We will address questions at the conclusion. Your PAYCOM and PMI CEU certificates will be emailed to you following the broadcast. Your PAYCOM certificate will come directly from PAYCOM, and your PMI certificate will come from our email. There is no need to request either one. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. A download of the handout is available on the side or upper panel of your screen. So Trey, a very warm welcome. Thank you so much for being here today. We're so happy to have you.
Yes, thank you very much for having me. It's an honor to work with an organization like First Healthcare Compliance. I definitely appreciate this, and thank you to all the attendees out there. Hopefully this will just be a refresher on some things, and maybe you'll end up learning a little bit of something new, but hopefully this, like I said, this is just a refresher, because whenever it comes to knowing what to do whenever there is a HIPAA breach, that's pretty important. And hopefully you haven't had to do quite a few HIPAA breach reporting, but knowing the process is key, and knowing the process can save yourself time in the future. And as you can tell from the title, you are under a little bit of pressure whenever a breach does happen. And like Catherine said, my name is Trey Scott. I'm an attorney in Dallas, Texas. I've been practicing healthcare law for the entire time I have been an attorney. It's all I do. It's all our practice does. Our practice handles everything from medical malpractice claims to administrative overpayment appeals with the government, HIPAA HIPAA breach investigations and reporting. We also help providers with license disputes, license revocations, suspensions. Pretty much, if it happens in healthcare, we end up doing it. So again, thank you for joining in today, and let's get started. So where are we going with this presentation? So first off, we're going to talk about the notification to the secretary, the notification process, what you have to do. Then we will discuss what actually is a breach, because that is important to know, because there are some instances where you think something may be a breach and it isn't, or there's something that you think isn't a breach and it actually is. Then we'll talk about who has to report, and like I said, to report or not to report, that is the question. I know, cheesy line, but whenever you're the presenter, sometimes you get to do some things that are a little bit cheesy. So please do not hold that against me. And finally, we will go through the actual reporting process with OCR. And what I mean by this is I'll show you the questions that the OCR portal actually asks. So, okay, let's go ahead and get started. Notification to the secretary. This is very simple. It's a covered entity shall, following discovery of a breach of unsecured PHI, as provided. A covered entity shall, following the discovery of a breach of unsecured protected health information as provided in 164.404A2, notify the secretary. And this is getting technical here and very legal, but whenever they say shall, that means must. It doesn't mean that you can possibly notify the secretary. It doesn't mean that you can, on a whim, notify the secretary. No, it means that you absolutely 100%, if there is a breach that you discover, you must notify the secretary. There is no ifs, ands, or buts about it. You have to absolutely notify the secretary. Okay. Sorry, my computer froze. I apologize for that. So, and let me go back really quickly. If you look at the regulations, the 45 CFR 160 through 165, I believe. It may be more. I can't remember off the top of my head. There's a lot of different aspects of HIPAA whenever it comes to HIPAA breach and what's required and everything like that. The focus of this presentation is about notifying the secretary. So that's what we're going to limit this to, because there's separate things, separate requirements, because you have to notify, as you know, you have to notify the individuals that were affected by the breach. You have to notify, if it's a large breach, you have to notify the media, everything. We're not going to talk about those aspects today. We are just going to talk about the process of notifying the secretary, what's required, and what you could possibly face if, and by that I mean what possible civil monetary penalties, things of that nature, you could face going forward. So, okay, if a breach involves 500 or more individuals. So for breaches involving 500 or more individuals, a covered entity shall provide the notification required by paragraph A of this section contemporaneously with the notice provided by 164 and in the manner specified on the HHS website, which we'll show you the website in just a second. But this is saying that you have to notify the secretary within 60 days of the discovery of a breach. And it's saying that you have to notify the secretary through the HHS OCR portal. And I'm throwing a lot of acronyms out there. HHS, as you know, Health and Human Services, OCR, Office of Civil Rights. So you have to notify the Office of Civil Rights of Health and Human Services. You have to notify them through their breach portal, which they have online. It's fairly intuitive, and we'll go over it in just a second. Now, notification of a breach involving less than 500 individuals. So for individuals involving, or for breaches involving less than 500 individuals, you still have to notify the secretary via the online portal, but you have more time. You have 60 days after the end of each calendar year. So if a breach were to occur, say March, if a breach were to occur in March, then you would have until March, I believe it's March 2nd of the next year of 2023 to notify the secretary, because it's 60 days. Like I said, if my math is correct on that. So 60 days from the end of the year, you have to notify. Ideally, how we recommend doing this is we recommend notifying once the investigation is done and once you've followed all the proper protocols of notifying the individuals, etc., that is required. We recommend doing it at that time so you don't end up forgetting. Other individuals, other law firms say put all of your breaches that may be 500 people or less together and set aside 1 week at the beginning of the year, and then go through the notification process to the secretary of all of those at one time. And that's just, you set aside that week to do that. I get that. I wouldn't recommend it because you may end up forgetting one. So it's, in my opinion, easier to notify within a reasonable time after the discovery of the breach, but before this deadline. But now you know how long you have to notify. So I keep using the word breach. So let's talk about what a breach actually is. A breach means the acquisition, access, use, or disclosure of PHI in a manner not permitted. So that compromises the security or privacy of the PHI. So that means that if someone that didn't have access or shouldn't have access to the PHI obtained the PHI, that's a breach. An example, a former client of ours was going to set up a email list of patients to where they could email notifications of their practice, like for example, when the practice would be open, when the practice would be closed, blah blah blah. and they were sending that Excel spreadsheet to a company like Constant Contact. It wasn't that company, it was some email marketing company, just so they could handle it all and it would just be easier, and they could also send other notices of the practice. Well, the office manager that was entering the email address for the person at the email marketing agency entered it incorrectly. And it actually ended up getting sent to a individual in Australia. And the Excel spreadsheet contained patient name, patient email address, and date of birth. Well, that was a breach because it was unauthorized acquisition and access of the information. OCR did an investigation, determined that it was inadvertent, and it was not intended. It was essentially a tier 1 breach. So they didn't end up fining the client. They ended up recommending some additional training, I believe, but they didn't end up fining the client. But that was a breach. You've probably seen on the news that breaches occur whenever there is the hacking of servers, and there's the virus where they come in and lock you out of the system. Those are in most instances breaches as well. So a breach is really any unauthorized acquisition, access, use, or disclosure, even inadvertent disclosure of protected health information. Some exceptions to what a breach is obviously you can disclose PHI to the individual or guardian. That's not a breach. You can disclose PHI for the treatment, payment, or healthcare operations. So you can disclose PHI to insurance providers. Obviously, that's not a breach. And then you can also disclose PHI to the government for investigations. Now, this is where an example of this is when, and hopefully this is not something y'all experience a lot of, but that occurs, for example, whenever Medicare and the Medicare administrative contractor, for example, Palmetto, Novitas, Noridian, all of those end up sending a request for patient records as part of a post-payment audit. Now, that is a investigation, and disclosing that information in the entire patient record is not a breach. That is authorized, an authorized disclosure, and obviously not a breach. Okay. As I said, a breach excludes any unintentional acquisition, access, or use of protected health information by a workforce member or person acting under the authority. So an example of this is in some instances, I'll provide an example of one of our clients. We have a client that has a home health operation, and they use electronic records, and because they have different nurses working, they only allow those nurses, and they're nurses that work for several different agencies, to keep it simple and make it easier. They only allow nurses to have access to the patients that they are going to be treating. So, for example, if a nurse incorrectly a nurse at a home health agency is wanting to enter information about their home health visit with that patient they saw that day, and then they're keying it in the online system, and they enter an incorrect name, and they're given access to a different patient because the barriers were not in place that would prevent them from having access to all the individuals. That is a unintentional access. That is not a breach. That was unintentional. It's by a workforce member. They were acting under normal authority, and so that is not, even though it is a breach per se, it isn't a breach for the purposes of notifying the secretary. Oh, my apologies. And then another one is if a sheet of paper is left out from, say, for example, you take your child to a pediatrician, and the pediatrician gives you a checkout sheet to take to the front desk because they still use paper records, and you end up leaving that sheet of paper at the in the room where your child was treated. Well, someone else comes in that room and they see your sheet where they talk about visits, essentially your your child's paper record in there. That is not necessarily a breach in that part, because the person that comes into the room next, they might see it, but they're really not going to be able to retain it. So that's what is in part 3. It's where it was they had a good faith belief that the unauthorized person to whom the disclosure was made would not reasonably have been able to retain such information. This also occurs with essentially overhearing nurses talking about patients where they're next to another patient's room, and there's obviously going to be things discussed, and that probably is not going to be able to be retained by the individual, so that would not be a breach. So, who has to report a breach? There are covered entities, which is a health plan, a healthcare clearinghouse, a healthcare provider who transmits any health information in electronic form in connection with the transaction covered by this subchapter. A healthcare provider, as a healthcare provider, you are a covered entity. Now, a business associate would essentially be if you outsource your billing to a medical billing company. That is a business associate. If you outsource your prescriptions to someone, that is another business associate. Anyone that a healthcare provider contracts with to perform a service in the aiding of providing healthcare normally can be considered a business associate. Another example of a business associate is a law firm. Law firms are business associates because, for example, our clients, whenever they are responding to government investigations, they send us medical records, and we in turn put the medical records all together and then send those medical records on to the government. We are a business associate on behalf of a healthcare providers. So that's why HIPAA training is important for attorneys as well, because we carry the same risk as what a healthcare provider does whenever it comes to cyber risks. Okay, so the deadlines I spoke about, the 60 days from the end of the year, or the primarily whenever it comes to notifying individuals and notifying the secretary of 500 or more, a breach involving 500 or more individuals, you're probably wondering what counts as the discovery date, because a breach may occur on, for example, April 1st, and then you don't discover it until significantly later. We had a client that had a former employee that randomly was able to guess access codes to the AHR, and they ended up siphoning patients off of our clients. And so that started to happen in like April, and then they didn't find out about it until September, whenever they noticed something was really wrong and started poking around. So the fact that the breach occurred in April, they don't have 60 days from when the breach first occurs. They have 60 days from September, whenever they first discovered it. Because breaches treated as discovered. A breach shall be treated as discovered by a covered entity as of the first day of which such breach is known to the covered entity, or by exercising reasonable diligence would have been known by the to the covered entity. That phrase essentially is like going back to the September example. Whenever my client first discovered it, they began an investigation as to, because they started noticing something a little bit weird about the medical records, and then they ended up having an IT person come in and look, and then after 2 days investigation, the IT person was like, hey, look, it appears that someone is gaining unauthorized access by entering one of your employees' codes at 1 o'clock at night. So even though they first technically discovered the breach on say like September 2nd, then they had the 2 days of the IT person's work. The date of discovery for purposes of reporting would be September 4th. So that can, I guess, buy you a little bit of additional time, but the safe rule is to, if you suspect a breach, count that day as the date for the 60 days. And then there are instances where you have ransomware and you find out about it that day. That's the date of the breach. So some discovery dates are a lot quicker to determine than others. Okay, to report or not to report? That is the question. Our basic rule at our firm is, if a breach occurs, report. And obviously, that doesn't include reporting things that are not breaches. For example, the employee accessing the home health nurse accessing the wrong patient. That, as we discussed, is not a breach. So it does not need to be reported. And as always, there are exceptions to the rule. And if you're able to demonstrate that there is a low probability that the protected health information has been compromised based on performing a risk assessment and investigation, then you won't have to report. Those are very, very, very limited situations where you won't have to report. An example of this would be mailing a statement or test results to a patient. You get the patient's address wrong, but it somehow gets returned to sender due to the address being incorrect, and you can tell it hasn't been opened. That obviously would be a situation where you wouldn't have to report because no one accessed that. So even though it technically was a breach because there was the possibility of someone accessing it, they actually didn't end up doing it. I'm trying to think of another situation. Another situation would be, in some instances, ransomware may not be a situation where you have to report. I would still report, but if you ultimately determine that someone tried hacking your system, but they were unable to do it, or they only got into your IT team was able to discover they only accessed your normal office procedures page or something of that nature. They weren't able to access any patient information, and your IT team is able to determine that. Then you necessarily wouldn't have to report it. Again, though, our recommendation is to report, because if you should have reported and you didn't, that ends up being a lot worse. And some of the factors for you to ultimately determine whether to report or not: the nature and extent of the PHI involved, including the types of identifiers and the likelihood of re-identification, who the person was that accessed it, whether the PHI was actually viewed, and the extent of which the risk to the PHI has been mitigated. So you need to perform a risk assessment and look at those factors as to whether to report or not. Again, my recommendation: always report. And just for some clarification purposes, you all should know this. If you don't feel bad. Whenever I first started in healthcare, I didn't know what PHI meant. Now everyone, or now it's something I see daily. Unsecured PHI means PHI that is not rendered unusable, unreadable, or indecipherable. For example, the spreadsheet containing the names, birth dates, and email addresses of patients of the clinic that were being sent to the email marketing company. That was unsecured. Protected health information is the identifiable health information that means names, dates, names, birth dates, email addresses, addresses, social security number, Medicare number, insurance number if they have Blue Cross Blue Shield, Aetna, things of that nature, any of their results, BMI, that all protected health information. Okay, so we're going to go to the OCR portal, and we'll talk about the actual reporting questions that they're going to be, that you are asked through this process. So that is the link you go to. You click on it, it takes you there. For purposes of this, I'm not going to click on it because the landing page you end up getting, I have placed on the slide. So here's what it looks like. You end up getting this nice landing page where it says, notice to the Secretary of HHS, breach of unsecured protected health information. So says to file a breach, please enter the information in the wizard pages below. And my apologies. Now we are going to exit out of this, and I will go through I'll go through a PDF that I printed off of all of the questions. So let's go through here. That's not the questions. I'll go over that in just a second. So let me move this around and I'll bring it full for y'all. Thank you for the waiting. Okay, so here is a list of the questions, and all information with the asterisk is required. So basically all information is required. So this is, what type of breach report are you filing? Are you filing an initial breach report, or are you filing an addendum to a previous report? An addendum, you can file an addendum to a breach report if you do things like conduct additional training of your patients, conduct additional training of your employees, you end up discovering more beneficiaries. Say you have a 499 breach, and then ultimately you end up continuing the investigation. After you did it and you determine it ends up being 501, you need to do an addendum to a previous report. That's what that means. Whoops. Okay. And then if you are doing an addendum, you have the breach, they give you a breach tracking number as you go through. So now this is asking the contact information. It's the next set. It's, are you a covered entity who experienced a breach and are filing on behalf of your organization? So this is if you are a healthcare provider and you have the breach. And this is, are you a business associate who experienced a breach and are filing on behalf of a covered entity? For example, this is a situation where if a medical billing company ends up having a breach, they would need to end up filing this on behalf of the covered entity, on behalf of you. And unfortunately, since medical billing companies have a lot of different clients, a lot of healthcare providers, they would probably have to file quite a few of these breach reports if they were to have a breach. And then finally, are you a covered entity filing because your business associate experienced a breach? This example would be where your covered entity, your business associate has a breach, but they don't feel like they should report, or they don't want to report, or they don't know the process to report, and you're just going to go ahead and do it because a breach needs to be reported. All right, and then you just have to enter contact information, type of covered entity, blah, 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 all the nice, wonderful stuff. Then you have to enter the point of contact. And then this is, if you're a business associate, you have to enter your information. Then you have to enter your point of contact. And then you have to enter the covered entities on whom behalf of you're filing. This is, as I was saying, if you are a business associate and you have quite a few covered entities that you experienced a breach on behalf of, you're going to have a lot of information to add here. And then continue to go through. And then it asks the type of covered entity you're reporting on behalf of. Then business associate, point of contact. Okay, now we get to the breach information screen. It ends up being, if you end up looking at it, it is the third option. And then this is where you select it's a breach of 500 or more individuals or fewer than 500. Now, here is where you enter the actual breach date. So, for example, my client that ended up having the breach in April, but they didn't end up discovering it until September, they would put that down. In most instances, hopefully, your breach only lasts for a day or two, and it's not an entire almost half a year. Hopefully, you don't have that happen. And then the discovery dates are here. As I mentioned, the discovery date is when you should have reasonably known when the breach occurred, or when you actually end up discovering it. So, for example, the client, the client, whenever they were reporting it, I did the fact that the discovery start date was whenever they first noticed it, and then the 2 days later, they had the IT person come in, and then that was when the discovery end date was. So, and the breach end date, going back up to that, that's whenever you've taken the final steps to prevent the breach. So, for example, of the one with the former employee, the breach end date was whenever they finally ended up changing the access code, and it ended up being the breach end date, and that was also the discovery end date of that. I would have liked for it to end up being the breach end date would have been the discovery start date, but unfortunately, my client did not do that. Also, the side, that's why you need to change access codes regularly, or make sure you at least change access codes whenever someone leaves your organization. Okay, and now we talk about the type of breach. This is hacking, an IT incident, an improper disposal, a loss, theft, or unauthorized access disclosure. And the little help thing to the side over there, that provides a definition to help you ultimately determine what category it fits under, and it's pretty detailed as to that. So you shouldn't have really any hard time picking an option. An improper disposal, I'll give you an example of that. we had a client that had a improper disposal because they were storing medical records at a off-site storage facility, and they managed to not pay the storage facility because they just forgot about it. And whenever that happened, the storage off-site storage provider or owner went in there, took all the boxes of records and put them in the dumpster. So that was a improper disposal, and that was not a fun breach. Loss, obviously you end up losing cell phone. If it has medical records on it, or laptop if it has medical records on it, I don't recommend having medical records on laptops if you can avoid it, or if it has access to your EHR. That's just my recommendation. Just make sure that if you are using a laptop, make sure you're not saving your password, make sure you're not saving any files, things of that nature to it in the event it gets lost or stolen. Because if you have to key in your access code to the EHR each time, then even though it's technically a breach, it goes into the it would go into what safeguards you had in place to ultimately prevent the unauthorized access. And then you can ultimately work with your compliance manager to determine if in fact that was a breach. Now, the location of the breach, again, this is desktop to computer, medical record, email, laptop, server, other electronic device, paper, film. So the improper disposal, that was medical records. You would end up putting paper films. And then here's what type of information was involved in the breach. You can see the clinical, demographic, financial, and there is all of these, you can click multiple ones. Let me just go back and say that. So for example, if you had a breach on your computer, then it would end up being let me go back up here. If you had a breach on your desktop computer and they hacked your server, it would end up being desktop computer, electronic medical record, more than likely, and network server. There's a chance it could also end up being email. So there is that. Now, let's go. You can see the other type. So you can also list the type of PHR or PHI involved in the breach under other. You can type it. Now, a brief description of the breach, and they do mean brief because 4,000 characters really doesn't end up giving you a whole lot of room to write everything that you possibly can about the breach here. So try to give as much detail as you possibly can, but you may have to limit what you say in there, because I like including what safeguards you had in place in the description of the breach. Even though it gives you an option to do that right there, I still like having that just to give the OCR more information and let them know a couple of times about what you have in place. Now, again, you list the safeguards. You have privacy rules, safeguards, security rule, safeguards. So for the improper disposal of the medical records. Unfortunately, my client really didn't have a whole lot of safeguards in place regarding that. He was able to have really just access because you needed to have access to the storage unit, but unfortunately that was really it. There were no other safeguards in place. And then here, the notice of the breach and the actions taken. This is where you have to get into the whole details of how have you notified the individuals, and like I said, that's kind of a separate thing about what you have to do to notify the individuals. But just know if there is a breach, you do need to notify the individuals. Substitute notice, really quick. That's just if, for example, you send the breach notification letter and it comes back and it comes back and says incorrect address, return to sender, then you need to do substitute notice. Media notice required. That's obviously if you have over 500 individuals, you need to do the media notice that allows you to a drop down of the state and territories you have to do. Now, after you discover the breach, you really need to end up doing things to make sure it's not going to happen again. And this is where OCR looks, the actions taken and the safeguards in place. That's where the OCR looks to ultimately determine if a fine is going to be imposed and what type of fine you're going to end up getting. So here's a list of what they recommend and what actions they say should be done. And it obviously gives you another option for other, and you can describe any other actions taken. And then here you just have to say that everything above here you're not lying about, and you're doing doing everything you can. If it's more than 500 individuals, some of the information is going to be made available publicly, and I'll show you that in the next PDF I'm going to go to. And so you enter your name and the date, generate. So, for example, we as attorneys can file these breach reports on behalf of our clients. We do quite often. We don't necessarily recommend our clients doing that on their if they have done it themselves. We don't, if they have retained us, then we don't recommend them complete this form, but you can complete this form. There's nothing that says you can't complete this form, and following these steps, you will be able to complete this form. Just make sure that everything you say on here is accurate and you're not lying about it in any way, because that's not good. Now, I said that some of the information provided on this form will be publicly available. So the list you do not want to end up on is this list. This is a list where the largest breaches occurred. Like, for example, Florida Healthy Kids Corporation, it occurred, state Florida, it was a health plan. Number of individuals affected, that is a very, 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 very large number. And it tells you how the type of the breach. It was a hacking, an IT incident, and the location of the breach was a network server. And was there a business associate? Yes. So you see there are a lot of breaches involving a significant number of patients, and that's what we don't want you to have happen, and that's why following first healthcare compliance guidance, hopefully you will never make this list. Things do happen, but hopefully you won't. So now, with that, we'll close all of this, and then we will end the presentation. Give me 1 second to pull this back up. Whoops. Gotta love technology. Okay. And there's that. And then questions.
Okay, Trey, thank you so much. That was a really wonderful presentation and very informative. So thank you so much. We do have a few questions, and so we'll cover those right now if we have a chance. So the first one is, if we report a breach, are there any financial penalties we might face? I think
Yes.
Yes.
Yes. Thank you. I mentioned that in the presentation, and I forgot to actually talk about it. I guess that was a good tease for the questions. So yes, there are possible penalties you can face, and there are tiers of possible penalties. Tier 1. That's where it was a lack of knowledge. It was not really anything that was too egregious of a breach. You could face a fine of $100 to $50,000 per incident if there's if you had reasonable cause to know that the breach was possible to occur. Then you can face a fine of $1,000 to $50,000 per event. Then there is willful neglect. That's tier 3. That is when you just straight up don't have any procedures in place. You have no compliance program. You have nothing in place. Then that could be a fine of $10,000 to $50,000 per event. And then finally, the last category is neglect, and this is not having a compliance program in place, and then you end up having a breach, and you still don't have a compliance program in place after the breach. Then that is just straight up neglect that is not corrected. That's category 4. And that is $50,000 per violation. And these numbers are actually adjusted for inflation. I don't know what the current totals are, but they are adjusted for inflation.
Okay, thank you so much. Okay. How about this? In your opinion, what is the main cause of a data breach? Is it hackers, ransomware, something else? What's your opinion on that? Or what is the data
Employees.
show? Okay.
Employees. Employees are the main cause of data breaches. Whether it's loss of laptops, whether it's theft of laptops, leaving it in a car while you go eat at a restaurant, and someone breaks in, steals the laptop, lost cell phones, use of email to send medical records that aren't encrypted. For example, not changing access codes, having an easy password, clicking on links in email that they shouldn't, which allows a hacker to get into your system. All of that it's the main cause of breaches are employees. And for example, the going back to the improper disposal, the reason that breach occurred was because an employee that was in charge of paying the office manager that was in charge of paying for the storage facility forgot to pay for the storage facility for several months, and they ended up throwing away all the records. So it is employees are the number one cause of breaches, in my opinion.
Okay.
The number one cause of avoidable HIPAA breaches are employees, and
Right.
that just unfortunately is something that, and why training is so important, and why you need a compliance program in place in your organization.
Right. Okay. Well, thank you so much, Trey. Do you have any other words of advice or anything you'd like to leave with us today before we wrap up?
I didn't. I do, and I'll just go over one more slide. Here are the sources that were used for the presentation. As you can see, the Code of Federal Regulations. Then we have the HHS.gov site. And then also, I use the First Healthcare Compliance HIPAA Privacy and Security Toolkit, and then the First Healthcare Compliance Fundamental Toolkit. Those are good, quick guides to look at and refresh, and it puts it all pretty much in one place. And myself being an attorney, so I don't have to Google multiple things, it's kind of nice to just have it in one place. So those are the sources I use. And the Code of Federal Regulations, that's easy to find. All you have to do is Google it, and then you end up going to law.cornell, and Cornell has all of it on the website, and it keeps it up to date. Really end up liking that website. But that's it.
Okay, great. Thank you. And for those who are wondering, you can find the First Healthcare Compliance books. You can actually find those on Amazon. And if you have any trouble also, then you can find them on our website too, under, I think, shopping cart. You can find those as well. But those are extremely helpful and real concise, and get right to the heart of the matter of what you're looking for. Do you have a slide that shows your contact information, Trey?
I actually do not. My apologies. I should have done that. But my email, if you want to reach out to me and you have any questions that maybe I didn't address today, or you want to talk about something maybe your organization is facing, my email address is Trey, that is Trey, at markkennedylaw.com. That's MarkKennedyLaw.com. So feel free to reach out to me after this, and hopefully, if you have any questions, I'll be able to answer them. Oh, my cell, my direct line is 214-998-3825. 214-998-3825. So if you want to chat over the phone because you have a really lengthy question, feel free to give me a call.
Okay, thank you so much, Trey. We'll also, in our follow-up emails to our attendees, we'll put your email address in there. So attendees, you can look for that. And then anyone who's watching this webinar later, they'll be able to hear this on there. So that's great. So attendees, if you have any questions, you can reach out to Trey directly, or if you would like also, you can send us questions and we'll forward them on to Trey, and he can answer those questions for you. So please remember, your PAYCOM and your PMI CEU certificate will be emailed to you from within 2 days following the broadcast. There's no need to request it. Trey, I wanted to thank you again so much for being here today. So thank you.
Yes, thank you. Thank you to all the attendees out there. I definitely appreciate getting to speak with you about OCR reporting. Hopefully, this was beneficial. I know there were some areas we didn't necessarily cover, like notification to individuals and notification to media, and just some other nuances about doing a risk assessment, things of that nature. But hopefully, if you do have a breach, this will allow you to report to OCR. And if you want to get an attorney involved to help you report to OCR, feel free to give us a call.
Great. Thank you so much. So, attendees, you can register for any future webinars or request a demo of our compliance solution on our website at firsthcc.com or call us at 888 543 4778. And thank you for joining us.